Good evening. We have just started this live session. This live session is for the course Patent Law for Engineers and Scientists. And this is a course that has been, NPTEL has been offering this along with SWAYAM in the recent years for quite some time now. If I remember right, since 2016, we have been offering this course. This course, along with another course, which is a 4 weeks course which is called Patent Drafting for Beginners. The object of launching these two courses in tandem was to ensure that those people who want to take the patent agent exam, and that, as you know, it's a central government exam that is conducted by the patent office, those of whom who want to take, and we found that there is quite a lot of people in academia and students, young students who are embarking on a career, who wanted to keep this option open of having to specialize in intellectual property. Even if they didn't want to take it as a full-time career option, they could at least know this and know that, they could, if necessary, they could also become a patent agent. So that was the objective of designing this course. And this course, we would have seen tens of hundreds of people who have thousands of people who have enrolled for this over the years. And this has been the object of the course. The course, in fact, if you see the way in which we have structured the course, it is the syllabus of the Patents Act, which is what gets questioned and queried in the patent agent exam. And we have also structured it in such a way that the question papers that you actually take during the exam are very similar to the multiple choice questions that you face in the patent agent exam. So this session, I'll just lay out what we can cover. We have received some questions on the Excel sheet. I will cover those questions. In this session, I want to focus on the learnings that you have come through across the course, and how can you implement that in format. You can implement that either in taking the exams at the end of this course, or if you have enrolled for the patent agent exam, what are some of the techniques and tools that you can use to crack both the exams. So this is a common session, but we will try to address the queries that you have. And if you have any queries pertaining to your submission of assignments, your access to the forum, or questions raised on forum, one of my teaching assistants, Ms. Mamta Sinha, is also here. So she can help you with that. She can either chat on Zoom or on YouTube live, or we can post those questions back on the answers to those questions on the forum itself. So with that, let me just give you a small update on what has been happening in the patent scene. And this update largely comes because of a new technology. Okay, and many of you would have come across it. It's called ChatGPT. ChatGPT is just the what you call it, it's one of the manifestations of a generative AI. So generative artificial intelligence is the technology behind it. Now, I do post some stuff on my LinkedIn account, and in the past I had posted a short video on how you can use ChatGPT for drafting patents. It's a very short take on. I just give a prompt and it just drafts a patent with dependent and independent claims. I also ask for process and product claims. It gives me that. It's a very smart work. You can see that. Now, this brings one issue to the fore. What will be the role of patent agents in a world that is enabled with AI? No, these are very early days, but we can see the prospect. There is quite a lot of drafting work that can be done by AI. You can see that. If you have tried using ChatGPT 4, you will see that. It's quite impressive. You could use ChatGPT 4 for even answering questions from the patent office. The FER, the patent office, raises a first examination report. You can put the questions there, you can put the context, and you can ask ChatGPT to generate a response to the FER, and it will do that. Now, largely ChatGPT has been trained on the US format. So if you ask, if you give a particular situation and ask ChatGPT to develop a response to an office action, which is what it is called. The FER is called an office action in the USPTO. It will do that. I mean, there are good amount of experiments around which you can see. Now, so this is one thing that we need to consider, because this is a tool that will help any patent agent to become better, without doubt. This is a tool. So that's one thing which I want to, we normally don't cover this in the course, because the course is on concepts and how human beings need to understand this. But now, because we have this a very capable tool, you should now look at how you can use ChatGPT for your work. Yes, this is a question that always comes up in the light of the Samsung disaster. How about maintaining client confidentiality? Okay, now the point is, ChatGPT, posting anything on ChatGPT is like posting it on the public domain. Let me make it very clear, very clear. If you post something on ChatGPT, it is as though you are posting it in the public domain. But in the days to come, you will find new tools emerging, new options emerging, wherein you will find that the generative AI will give you the option of do not train. Now, do not train is something which you need to study a bit about. Now, do not train option has been, there are no slides. It's just, I mean, we are just having this is just an oral session. We don't have, in fact, most of you have switched off your cameras, and I've also done that. This is just, there are no slides. We are just giving you an brief outline of what the course has been and certain recent developments in the field, which is we are just talking about the use of ChatGPT in for patent agents or people who are specializing in this field. Okay, so this you will see Adobe had recently incorporated a do not train option. The do not train option, what it does is it does not take your personal data and it is not used for training, which means your personal data remains locally on your computer. This is important to understand. So when those tools come, ChatGPT is not such tool. Maybe ChatGPT in the future may give you that option, the do not train button. You just put the do not train button or engage that button, then it will not take your stuff and put it into the public domain. Your stuff remains with you. And these iterations are going to happen. I mean, the one way to look at this entire field is that Google and Microsoft are investing billions into this field. They will ensure that all these small things that we worry about, client confidentiality, data, and share privacy of data, these things will get sorted out. Take it from me, these things will get sorted out. So I'm talking about the near future, where you will have tools developed by different service providers, which will give you this tool to draft a patent, or give you this tool to generate a response to an office action, say a response to a first examination report, wherein you will have to put into the system matters that are confidential. You have to do that. FER not so much confidential, because the FER is already there on the patent office website and there's not much there, but at least while filing a patent or drafting a patent, there is quite a lot of, and it's inherently tied to the concept of novelty. So the AI engines will soon have a provision, and we have already seen that in Adobe's Firefly. They will soon have a do not train option, wherein your data will not be taken. It will remain locally, it will be analyzed, and it will give you the results. Your data won't go anywhere. I mean, these things are coming up. I've not tried it for the question whether you can use ChatGPT for generating a response to an FER. I've not tried it for FER, but I've tried it for an US office action, and the answer is really impressive. Really impressive. Some of the sites that were given, the prior art citations, they didn't match, but it's just a matter of time. There will be some company that can train ChatGPT specifically on patent data, and then that result is going to be exactly what you want. You know, you can actually use prior art. The patent office will be using AI to generate FER, and also the patent agents will now be using AI to file replies to it. Okay, copyright infringement. Copyright infringement, the people who develop AI have been very careful. I mean, if you see all the statements, if you look at the, there is a technical release for ChatGPT 4 on how ChatGPT operates, what are the things. Well, it's a technical document. If you see that, they will tell you that there are few things that the ChatGPT is not trained on. One, it is not trained on copyrighted stuff. There's no training. It's very clear. It is trained only on data in the public domain, which is things that are not in copyright. Third, it does not use, or right now it is designed, they've built in some provisions, not to use data that is private to a person. Like what happened in Italy. Italy had to pull out of, had to ban ChatGPT because it was not complying with GDPR. GDPR is their privacy law. The Europe has a privacy law, and it's called the GDPR. So they were not complying with that. So these, again, coming back to the point, these are small issues that will get sorted out as the technology, as more investments come into the technology, and as the technology, the value of the technology is much bigger than the small incidents that are happening. So copyright infringement, with regard to the training, there are two aspects of copyright infringement. There could be infringement of the training data, what is called the input into the AI. That's murky. We don't even know what is being used. Sometimes you ask for a summary of a book, it gives you a huge summary. You can even ask, it may give the summary with the paper, with the page numbers. If you ask for references, it will even give the summary with the page number. So for all you know, the ChatGPT may have access to that copyrighted work the way it is doing, or it is picking up it in something like a mining. It's doing a mining and it's just giving you some bits of it, like what the Google Books does. It's doing just some mining and it is showing it. So that's one part of the copyright thing that we worried about, the copyright in the input, which is largely training data. There is a copyright issue with regard to the output. Sometimes the copyright, the data that the AI generates may look very similar to a copyrighted work, or may have incorporate elements of the copyrighted work. Now, this is something which, but if you see the way the generative AI works, it can churn out materials in different format. You can say that, give me a fifth grader understanding of quantum quantum theory, it will give you a fifth grader's understanding. If you say, give me a person with is a master's degree in physics, then it's going to give you another answer using the same tools. So we do not see a copyright infringement in the output, because the output is largely, it's like a compilation of things. And as far as the ChatGPT gives a reference, it's okay, because you are just summing up, or you are just paraphrasing something that already exists, and you're going to give the references. So references, and you already have some plugins which will give you references, and there are ways to tackle this. So the bigger issue is with regard to the training data, which could amount to copyright infringement. Right now, ChatGPT very clearly says that it does not use copyrighted material for training. It's very clear. It's very clear. But again, because it's an open AI and the training data sets could be quite complex, and it will be very hard to enforce copyright. Now, there is another issue attached to the second part of the issue, is like, can copyright, can works generated by ChatGPT be entitled for copyright? Now, US has taken a view that they should not be, and I feel that that's the right view to take, because these generative machines they're not like humans. Okay, if a human being needs to write a book, it's going to take that person a few months, depending on the volume of the book and the topic covered. But ChatGPT can do it in minutes. And if we allow ChatGPT works to be copyrighted, the Copyright Office will not have anything to do just by granting. And if somebody wants to register them, we know that copyright can subsist because of the Berne Convention without registration. But if somebody wants to do that, that will be a huge problem. And in an earlier session on intellectual property course, I had mentioned the distinction between machine creativity and human creativity. And the IP systems that we know today are designed to incentivize human creativity. And machine creativity should, I'm not saying it's not important, but they do not fit into this bucket. We may have to, if we need another bucket, we have to create that bucket. Okay, now just coming back to the point. Now, we are living in an interesting time where the patent agent exam, which is largely this paper and the patent drafting paper, will take an entirely different shape. And we could, going forward, if this tool becomes available, it's already available to the masses. then the way we have to structure patent practice for patent agents will have to change, because these tools are very powerful, and your ability to deal with these tools will make it the outcome different. So you may ask, if all these things are there, if I can draft a patent with great precision using ChatGPT, and if I can answer FER using ChatGPT, then what is my role? Now, here is where the human layer comes in. You will find that even to use these tools, you need to be grounded on the concepts of patent law. And a person who understands the concept of patent law is going to get a much better answer, much better outcome from ChatGPT or any other AI. I just use ChatGPT for any AI. And AI, you will know that there are already AI-driven systems for patent drafting. I mean, there are companies which give these tools, and there are entities who are already using these tools. So we are talking about a system which is trained on a specific data. We are talking about all the patent literature and the non-patent literature, which could be, we're not talking about Wikipedia entry, we are talking about the ones that could be cited, that is normally cited as a prior art. Let us look at that as the yardstick. Something that is normally cited as a prior art by the patent office, we are looking at these as the data set. So patent office looks into something as a prior art, and if it cites that as a prior art, then that could be the data set on which we could train the generative AI. Now, let me just look at, there are some questions here. So just to give you that this exam is a multiple choice exam. All the questions are in the multiple choice format. In some places, you will have choices where one or more choices are correct. So you may have to answer that accordingly. Other than that, it's only a MCQ exam, because we try to emulate this exam like the paper 1 of the patent agent exam. So that's the parallel. In paper 2, there is a descriptive part where you will have to write things. And this is one of the questions that I received, that part 2, what should be the tips for taking the exam? Now, the tips are very simple. In part 2, there is a drafting part where you have to draft patents, which is already, you know how to do that. The descriptive questions in part 2 are actually questions which are problems which you have to solve. They are situational problems which you have to solve. A situation is presented to you, and your advice as a patent agent is asked for. So you will know that if you read those questions, you will know that your knowledge of the law can help you to answer those questions. It could be revolved with regard to a novelty disclosure. What happens if there is a novelty disclosure? It could be with regard to a strategy for filing patents, whether you need to do the provisional first or directly for the company, small things like this. So what you find in the part 2 descriptive paper is actually an application of what you have learned. So whatever you covered in this paper is good enough for you to answer the descriptive part. But the only point is you have to answer that in the form of an essay. You have to, so when you read the question, this is a technique that you can see. When you read the question, you start noting down in a rough sheet, you start noting down what are the things that the question is covering. The question may cover patent of addition. The question may cover infringement. The question may cover priority. So note it down, note down the salient features, and then see what is the question that is being asked. Now, if you note down these things, you will immediately recollect, oh, priority, what are the relevant provisions on priority? Patent of addition, what are the relevant? So you can just bring your knowledge and use the provisions and the knowledge that you have about these provisions to answer the situational question. The situational question is largely, it is designed, if you see the past question papers, it is largely designed as a question in which they seek your advice. And you can't just give your advice without citing the provisions. So citing the provisions, sometimes you may not know what is the exact provision for patent of addition. Then you can just, even if you don't know the exact provision, you can just give the sections in this or under this chapter. You can provide the chapter heading, the chapter number, or you can even say that these are provisions. You can describe the provision even if you can't recollect the section perfectly. So this is how you do it. You have to analyze the question. You have to see what are the provisions in the law and the rules, or sometimes even the form, that you need to incorporate into the answer, understand what the question is, and use the provisions to give your answer. So you are essentially giving a advice. So all the questions are like this. Sometimes they ask for a descriptive. You also have some descriptive questions, but most of that's easy. I mean, if somebody asks you what is a patent of addition, you can just describe that. But the point is, the difficult part comes in when you have to apply what you have learned to solve a question, or to solve or to answer something that they have asked. So essentially, you are giving advice through that process. So this is one of the questions that was asked. So I hope I addressed that. Okay. Now there is another question. As an international student, what is the easiest way for me to understand the laws and remember which one to apply and where? Okay. Now in one of our early sessions, we had something in the introductory part of the course. We had a short session or a lecture on the design of the Patent Act, or on the life of the patent. So what you need to understand is that a patent is like any other thing. It has a beginning, it has a life, and it has an end. Okay, like most things, like all created things go through this pattern, just like human beings or like any material object. There is a beginning or a birth or a starting point. Then it has its own life, and there is an end for it. Now, the patent system, the Patent Act is designed on this. If you see the chapters, if you just see the chapter headings of any act, let it be the UK Act or the Indian Act or the EPO, any of the patent legislations, they are largely designed on the structure. There is a beginning on how to apply, and there is a life, there is a grant process before the application. Once it is granted, then the life continues for 20 years. And after 20 years, it expires. This is the normal case. There's a 20-year period. So the entire Patent Act is designed around this life. How to apply, grant, procedure before the grant, procedure after the grant, how to maintain the patent by filing fees. What if there is a compulsory licensing application? What happens if things get infringed? Actions on infringement. There are some rights of the government with regard to the patent. And expiry. Expiry is what comes after the patent expires. It falls into the public domain. Now, the way in which you can relate or remember these laws is to understand the scheme of the act by applying the scheme of the act to the life of a patent. So whatever I said now, there is a beginning, there is a life, and there is an end. This is how the scheme of the act is, most of the acts. So who can apply? Application, what happens after the application is filed? When is it published? When is it examined? Is there opposition to a patent that is being filed? All these things come before the grant. So the grant is one thing, that the time at which the grant happens, then the life of the patent starts. Till then, it is in its pre-life mode, or it is in a state in which it is not enforceable. It is not at a right. So once it is granted, it becomes a right. And then that stage continues till the remainder of the 20 years. Sometimes it may end abruptly if somebody challenges the patent and or invalidates the patent, in a proceeding before the court, or as a defense in an infringement suit. Then the patent will have a shorter life. It may not have a 20-year life. Or for some reason, the applicant doesn't want to pay the fees. They find that it's no longer relevant to have this product in the market. Then they will stop paying the renewal fee, and the patent will get lapsed. That's another way the life period can be for a shorter term. Or, for instance, the patentee voluntarily surrenders the patent. There is 63. You can see the provision. There's a provision for surrendering a patent. Or if the patent is surrendered, again, the life is going to be short. So all these things you can now understand, and this is a good way to remember it, is that any provision that you see, restoration of lapsed patents, or compulsory licensing, or opposition before the grant of a patent, you now try to place that somewhere in this line, in the line which is nothing but the line that begins with an application of a patent. At the center of the line, you have something called the grant, and at the end of the line, you have expiry of the patent at the end of 20 years. So once you have this mental line in your mind, any provision that comes in, you can place it either before the grant or after the grant. Okay, and you can place it between these two things: the beginning, that is which when you file an application, and expiry. So this will give you a framework to understand the laws and to remember them. So that was another question that was posed. So I hope I answered that. There is yet another question on patent of addition. Is it applicable for PCT application? Now, PCT application, as you understand, I mean, PCT, you need to understand the scheme of PCT application. PCT application is nothing but it's a glorified mechanism to, you can call it a postal mechanism or a courier mechanism. Okay, it's a glorified system by which you can file an application and ensure that the application comes in all the jurisdictions where you want it to appear. So I can file a PCT application in India, and after 30 months, it will appear, if I want to, in US, it will appear in UK, it will appear in Japan, it will appear in Germany, wherever I want it to appear. So it's a mechanism, it's a centralized mechanism for filing application and for prosecuting them. So while filing application and prosecuting them, the central mechanism allows you to file it. Little does it mean that there is a central mechanism for grant. No, there is no central mechanism for grant in PCT. PCT is just a facilitating mechanism by which the individual patent office where you want your application to come, say the US Patent Office, will have to take that application, prosecute it, and grant it. Okay, so because this is the centralized filing mechanism, and it is not a mechanism where you can and it's a mechanism by which all countries participate. You will find that patent of addition is not something that is there in all the countries. Some countries have patent of addition, others don't have it. In fact, some countries prefer that. In fact, even if you look at the, I mean, I did this some time ago. If you look at the annual report of the Indian Patent Office, okay, the number of patent of additions filed are very few. And the last time I saw, it was a few years ago, there was something like less than 10 patent of addition filed. Now, what does that tell us? It tells us that a patent of addition is something that is seen as an inferior thing compared to a full-fledged patent. Why do we say that? Because in a patent of addition, the timeline, the priority date, and the expiry date are linked to the original application to which it is an addition. So an addition means there is an original application, and this is going to be an addition to that. So the lifeline that you get out of filing a patent of addition is not 20 years. It is going to be much lesser than 20 years because it is going to be tied to the earlier application. So because of this reason, you will find that, especially in India and in other countries where they may have patent of addition is not seen as the thing that it is not the first choice of a patent agent or a patent applicant. Now, you may ask, then the level of inventiveness, because if the level of inventiveness is small, then patent of addition, because it is based on the earlier disclosure. What if the level of inventiveness is completely new? Then it may merit for a new application. Now, all these things are details, but understand that the PCT is what the law provides for in that particular country to accept an application which can be sent to other places. So right now, we only have PCT for complete applications, not for patent of addition. So even though we have a patent of addition, you cannot now add something on the PCT. You can, if the application is still pending, based on the nuances in the local patent law, you may be able to do it. Based on the if the local patent law of a particular country allows you to add something while the application is pending or after it has been granted, You may very well do that. But the PCT in itself, as far as I remember, does not have a patent of addition provision. The only thing you can do is to go ahead and file a separate application. I'm just saying this from my memory. Okay. Yeah, everyone, please mute your mic. We are getting some noises. Unless you want to speak, please mute your mic so that we can avoid background noises. Thank you so much. In case you have joined, I'm just reading out a comment. In case you have joined on a mobile, please mute it from your side because we are hearing some background noises from your end. Okay, thank you. So that's a thing on patent of addition. Yeah, are there any questions? Let me see on YouTube live. Yeah. No questions here. Are there any questions on the chat, Zoom chat? I think we have answered all that. Yeah, so you can, if you have any questions, please use the chat. If you have any clarifications on the course, on how we, it's pretty straightforward. We've been running this for probably 6 years now. So if you have, yeah. Okay, okay, again, this is beyond the syllabus, but I'll answer that. What about the Viva OC for the patent agent exam? Okay, Viva OC, there are 3 things they normally cover. Okay, 3 things, and I always tell this: once you clear the exam, and then the results are out, and your results are good enough, they are called, only then they call you for the Viva OC. So you need to worry about it at a later stage. Assume that you're called for the Viva OC. There are 3 things that you need to cover for the Viva OC, because these are the 3 things that they would ask you. The first thing is your knowledge of paper 1 and paper 2. Obviously, you took the exam, they're going to just check, so you have to brush that up. So probably there may be a big gap between the exam and the Viva OC, so you need to just brush it up. So they may ask you some aspects from paper 1 and paper 2. Be ready for that. Second thing that I've seen people ask, the board, the Viva OC board asks, is in your domain. They may ask some questions. They may ask you, what is your basic degree or your master's degree? Or if you have a PhD, what is your PhD? And in those domains, if there is a person who knows that domain in the board, they may ask you. And this is something which I've seen as a repeated pattern. Depending on the board, we don't know who's sitting on your Viva OC board. If there is a person who has some background of your domain, it is likely that they will ask questions. So bear this in mind. You have to be, I mean, this is something which you have done. So if you need to brush up something, you can just brush up and go. Right? So this is the second thing. The third thing, they will look at you as a person who will be the conduit, or who will be the connection between the client and the patent office. So this is the job of a patent agent. What does the patent agent do? The patent agent is a representative of an inventor or an assignee, the client, and he or she is the spokesperson of the client with the patent office, and he is also the conduit, or the person who conveys messages from the patent office to the client. So they will look at your soft skills. They will look at how you are as a person who will be doing this job of connecting the client to the patent office. So you should be, there are some things they will inquire with regard to, because if there is a hearing, then you'll have to attend the hearing. You have to present your arguments. They will see whether you are a person, they'll test you. It may not directly, they may want to know how good you are in your communications, written communication, oral communication. If there is a video hearing, then what will be, can they trust you to convey the legal issue or to address the legal issue that an FER raises? Small things they will look at. So this is what I call the third category, which is your communication skills, your soft skills, how you are with people, how you are in representing clients, how you are in addressing an authority, how you are in facilitating them to come to a decision. So these are the broad 3 things that you need to worry about when you get an invite for the Viva OC. Yes. And there are, I mean, there is a there is a YouTube channel called Lex Campus, which I started many years ago. All the stuff there is freely available. So there is some workshops, webinars I did on how to answer Vivavos. You can just search that on YouTube and you may get that. There are some more points there. Yes, any other questions? Okay. Okay. So if there are no questions, and I understand that it's working. Yes. Yes.
May I ask a question?
Please go ahead.
Sir, I was going through some granted patents on the patent website, Indian Patent Office website. So I saw a Form 3 filed on the website on some granted patent, and it had no countries listed where they have applied for patent. Is that a common practice to do so?
Good question. Good question. See, it's, I won't say it's a common practice, but it's a strategy some people adopt. Okay, I don't know whether it's common because I don't know the total numbers, but some people see Form 3 is actually a compliance requirement. Okay, like your form, I think Form 26, Form 27 on working. You know, working of a patent. There's another compliance requirement. The law requires you to comply. So what people do is they file the form to tell the patent office that I've complied, I filed the form. If the details are not there, the patent office is going to ask you, oh, where are the details? Okay, so that's they still get another chance. They'll get another shot at it. So this is, I mean, I don't subscribe to this, and I will not even advise this, because as a professional, the way you deal with the patent office, and this comes to the third point that I just mentioned, the way you deal with the patent office is going to indicate what kind of professional you are. Okay, and your name is going to be in any form you file. There's no way you can file the form and not feel that, you know, somebody else did it on your behalf. No, you are the agent and you are in charge. So how this is from your integrity and from your truthfulness, that when you file something that is clear and it serves the purpose. Okay, so I don't believe in this blank form filing, but I've heard about people doing that, because tomorrow if somebody says that, oh, we are going to penalize you for not filing Form 3, then your answer could be, hey, I filed Form 3. Then they will say that, no, you filed it, but it was a blank form. Then you could argue and say that, no, the law only requires me to file it. It does not require me to. You understand all these. It's a childish argument, but I would not advise any one of you to take that path. Form 3 is a requirement. We comply with that requirement, and we comply as a professional with all the details. Hope that answers your question,
Yes,
Ritika.
thank you. Thank you.
Yeah, welcome. I heard this before in the context of the working requirement. You know, the working requirement requires you to file, I think 27, Form 27. It requires you to file that on a timely basis. And there were these smart cookies who used to come and tell me, I filed the form in blank. How do I say, why did you do that? No, it only says file the form. It doesn't say that the form, that's deception. I mean, it means you have to file the form fully filled. It doesn't mean that you can just file the empty form and say that I've complied. In my books, you have not complied with the requirement and I can take action. That's if I was the controller or the assistant controller, I will take action against them as though they didn't file anything. Yeah, because it's deception. I mean, you have to be clear in your thing. It could also be a technical error. You know, they just uploaded a blank form. But if you're seeing a pattern, it may not be a technical error. You know, there could be some strategy behind it. Yes. Okay, if there are no more questions, then we can wind this section up. Don't worry, even if you think about something or you have something, please write to us on the forum. We would definitely want to help you in whatever way we want. There is one question that that has been asked repeatedly, and we had just sent a notification some time ago. People kept asking me about the BAR Act, the Patents BAR Act that is used in the videos. You know, sometimes you see the BAR Act. So the thing is that we used to publish this book. We used to publish this book called the Patent Bar Act. The Lex Campus used to publish it, but then we stopped doing that because of the constant amendments. Okay, the amendments are, I mean, they come thick and fast, and sometimes you cannot, you publish 1,000 copies of the book and you find that within few months a new amendment comes in and the book becomes outdated. So what we did this time, I'm just sharing the link with all of you. We have a Kindle version of it. Okay, this is the most up-to-date Bar Act, and as you know, it has got cross references. The act will have cross references to the rules and to the forms. So even if you read a provision, you will see what are the corresponding rules in the margin. You will see that, and you can also see the corresponding what you call forms. If there is a form connected to the rule, you will find the form mentioned in the margin. So in one shot you get it, and there are some short case laws, so just in case you are interested. So it's a bicolored act. So what we did, we did not publish this book after that. After the 2021 amendment, we did not publish it. We rather, it's an updated version is now available on Kindle. So I just share the link because I get this question many times as to where can I buy that book? The book is out of print, but because of this reason, you know, tomorrow there's a small amendment, the book has to be printed again, and just look at the waste of printing 1,000 copies and then selling a product which is not compliant or not up to the mark. So we just thought, you know, it's a better way to release the Bar Act as a Kindle edition. Okay.
Excuse me, sir.
Okay.
Am I
Yes,
audible?
please. Yes, go ahead, Rajesh.
Sir, I have a question related with the ordinary and conventional application.
Yes.
So as we say this, we have to first file the basic application, but that will be the ordinary application using form 1.
Go ahead. Okay. Yeah.
Yeah, that basic application that we'll file, that is using form 1.
Yeah.
Yeah, and within 12 months again, if we want to file the conventional application, so again using the same form 1, we have to take that option convention.
Okay.
Then?
Yeah, good question. Good question. Now let me just clarify that. The ordinary application, we use the word ordinary application for a domestic application filed in India. Okay, it's a domestic application. It does not go anywhere. It is, we understand that as an application, ordinary application using form 1. For everything we have form 1. I'll come to that later. For everything we have only one form. Okay, form 1 is for all the application. You just need to tick what you want to do. Okay, now in India, if you file an ordinary application, okay, and after some time, okay, the convention application, you will not file for that invention. You will not file it in India. Okay, let me clarify that, because this application is the first disclosure you made of the invention in any part of the world. Let us assume that you first filed an application in India as an application in the Indian Patent Office. Because Indian Patent Office is a party to the Paris Convention, this application can become the basic application. Okay, that's the first point. The ordinary application that you filed in a convention country has the potential to become a basic application. Now, when does it become a basic application? It becomes a basic application when you follow up in one of the other convention countries other than India, say UK. Okay, you follow up within 12 months, you follow up with an application under the Paris Convention in UK and say that treat this as my convention application and take priority from my basic application, which is the ordinary application that I filed in India. So this is how convention applications work. Okay, you don't file the same convention application in India like PCT. No, it is not the case, because once you file one complete application in India, that becomes the basic. Wherever you file, it's not in India, wherever you first disclose, the patent office to which you first disclose the invention, can be in India, it can be in UK, it can be in Germany. Wherever you first disclose the invention, the patent office to which you first disclose the invention through a complete specification will now, as long as it's a convention country, will now that application will be treated as a basic application. So if you file the basic application or the first application in India, that becomes the basic application. Your convention application has to be in another country. You understand? It has to be in another country. It can't be in India, because in India, you're already covered. And the convention application, if you read the provision, it is to use an earlier priority using an earlier filing in a convention country to enter another convention country. Okay, so what you will do is if you had filed the original application in India, within 12 months, you can enter UK, same application, telling UK that treat my India as my basic application, because that was the first disclosure I made of the invention anywhere in the world. That was the first patent office to which I made the invention. And India is a convention country. Hence, I am entering it within 12 months to UK using that priority. Is it clear, Rajesh?
Yes, sir. So I have to contact the UK patent office to file that, or
yes,
in the same IPO we will file that.
No, you have to see the idea of the convention application is that you want to go to many places, many countries around the world within 12 months. That's the idea. That's the basic principle. So the idea requires you to file one application in a convention country, whichever country, which is a part of the Paris Convention. So the first application you file, okay, if it is India, then that is your convention application, but it's a basic application. You understand? Yeah. It's a basic application. Now, India is already covered. Now you can, the idea of a convention application is that you want to go to other places preserving this priority. Preserving this priority. So
which option, while submitting the file application in India, I have to take that option, convention application?
No, and not necessary. You can cite the application because India is a convention country. You can cite the application and say, when you enter UK, you can say that I have filed in India. This is my Indian application number. Treat that as a basic application. I want to enter the convention route. So this is an option you use. So let us twist the table. Assume that you filed a basic application in UK. Assume that you filed it in UK. Within 12 months, you want to enter India. Now, what you will do in India is you will file an application in India, ordinary application. And we have a convention in the form there's a convention application. You file a convention application and you say that take my priority from the basic application that was filed in UK. You understand? So if there is an earlier application in India, there is no need to come here again. There's no need. See, but PCT operates in a different way. PCT, you may have a domestic application and you may also file a PCT application, but that's not how convention applications work.
Sir. Got it. Thank you, sir. Thank you.
Welcome. Okay, there's a question here. When we file a complete and it is allocated a category, say chemical, is it possible to change the? Okay, the categorization is done based on analysis that the patent office does. Okay, there are some things do get classified in wrong ways. I mean, I have personal experience because we did a study of hundreds of pharmaceutical applications, and we found that some of them were categorized as biotech, some of them were categorized as chemicals, some of them came under pharmaceutical. So this is completely left to the patent office on how it does it. Sometimes the classifications are robust, sometimes they are not, and sometimes the nature of the invention is that it could fall into multiple categories. So that's not it doesn't change your invention in any way because it's something that the patent office does. If the patent office does a wrong classification, it won't come in search. That's all. The only outcome is if somebody is searching for it, it may not come if you choose those categories. But nevertheless, it doesn't affect your patent in any way. I don't know why we should request a change because, as I said, it's an internal affair of the patent office, and the only thing is that when somebody searches using that code, the CPC code or when they use that IPC code, it will not show because it is classified in another place. That's the only fallback. It doesn't affect your right, and I don't think it affects your right in any way. And I know multiple instances where the patent office classified something in a wrong category, but it doesn't affect it. I mean, your application doesn't affect it, it gets granted. That's and the same application in another office may get classified in a different category. I mean, this is what the patent officers do. We have no control over it. Okay, any other questions, comments? Yeah, I'm just checking the YouTube as well. There are no comments on YouTube. Very few people are on YouTube. Okay, fine. Okay. So if there isn't anything, then we can just, okay, there's a question coming up. Okay. Yeah, no, see, I'm not a great fan of memorizing sections by rote, and I would not even, I mean, in today's world, I will not even pose a question where it tests a person's memory of a section. I mean, come on, we live in a world where you can walk with a barack to any place you want. You can walk to the patent controller with your barack. You can argue a case before a court with your barack. There is no requirement for this memory and giving the provision and the subsection. I'm not a fan of this method. In fact, the patent agent exam can be in the light of these technologies like ChatGPT. I think we should rethink the way we question people and we test knowledge. We have to rethink that, because what's the point in asking people for some section? So I would say that if the section number and the provision, some people do give some weightage to that, but even if you get the section number right, you are good enough. I mean, or even if you can't remember the section number, at least give the title and mention a line about what the section is about. Yeah, I know it is difficult. I mean, it's, if you ask me, it's completely useless to require human beings to remember all these things. It's completely useless. If you ask me, there's no real life situation where you can, other than showing off to people that, oh, section 8 is this and section 9, there's no real life instance, because in all places you can use the BAR Act, you can look into the act, you can consult the BAR Act on your phone, whatever computer, and you can read it out in a court, in a patent office, in any place. I mean, I don't see the logic behind this form of, maybe this was the this was how we evolved these exams, maybe, but they need to change. Yeah.
Sir, there is a question in the forum. Should I just?
Okay.
I'm just putting in the chat.
Yeah, please.
Yeah, sure.
Do that. Do that. Thank you, sir.
Yeah, this is a big question.
Yeah. While drafting a claim. Okay. I quickly understood the question. See, this is more like from what I can see, it's more like a Marcuse claim. Okay. Sometimes chemical compounds you need not. You mentioned in a Marcuse is largely on the organics compound. You just give a R on a R1, where R can be an ether, ester, whatever. You know that. People who know organic chemistry know that. So if it's a Marcuse claim, it depends on what you are claiming. Okay, if you're claiming the Marcuse structure, but here it's very clear, N is a calcium nitrate or ammonium nitrate, but N can have variance. That's the point. I'm referring to the Marcuse structure to say that where an element in your invention can have variance, then you claim the structure with the variance. So your main claim will be in the structure of a Marcuse claim, where you mention N. And you can have subclaims where N is ammonium nitrate and where N is calcium nitrate or sodium nitrate and all that. Okay. So what normally is expected if you are claiming in this structure, that you need to have you need to enable the examples. This is one thing to bear in mind. So normally from an examination perspective, I don't think this is relevant, because very rarely have I seen you will have sometimes you can take a chemical question may come in a choice, but normally people prefer mechanical questions because that's much easier and straightforward. And chemical questions normally don't have diagrams. You know that. It's hard to bring diagrams and you can't illustrate that. So from what we have seen, there is a choice. Every year you get at least one question on a mechanical invention, and that's how it's easier to clear the exam. I mean, even if you have a background in chemistry, still you would do better by taking up a mechanical question and answering that. Okay, now is it essential to write down all the salts in the product claim while drafting to mention or 2 or 3 salts? No, this is what I said. How are you crafting the claim? If you are crafting the claim as a Marcuse structure, you can mention N. Okay. And in the dependent claims, you can say where N is calcium nitrate, where N is sodium nitrate. You can do that. You can do that. But if you are claiming you're not claiming the Markov structure, you are claiming a specific embodiment, then you can have multiple independent claims. It depends on what the invention is. If you think, if you say the nitrate element is it's an integral part of the element, then I would claim the most and the integral part of the element can exist in 3 forms. I would claim all the 3 forms to be on the sure side, because I don't want my competitors to, because I claim calcium nitrate, I don't want my competitors to come back and say that only calcium is claimed, I'm claiming ammonia nitrate. So this is the thing. I would claim all those things. I would either have a broad independent claim and dependent claims which flushes out the detail, or if my invention is so important that all the 3 forms are equally important for me, I may even try to devise them as 3 separate independent claims. Hope that answers. I mean, I know it's on the forum, but anyway, yeah. Okay. See, efficacy in simple terms is effectiveness of a drug. That's it. That's all you need to understand. Is the drug effective? Then it is efficacious, or it has efficacy. Okay. Now, for the drug, what is efficacy? For a drug, why do we have drugs? We have drugs because we have an ailment or a disease and we want that to be cured. So the drug's efficacy comes from the therapeutic effect, because drugs are only had for that purpose. So because a drug's outcome, the expected outcome of a drug is therapeutic effect, we refer to therapeutic efficacy. Now, section 3, which you have just said, 3D, also applies for pesticides and chemicals, agrochemicals. Now, what is the efficacy of a pesticide? Efficacy of a pesticide is the ability of the pesticide to kill pests. If it is an insecticide, it's the ability to kill insects. Okay, so there we are not talking about therapeutic efficacy. We are talking about pesticidal efficacy, or we are talking about insecticidal efficacy, or weedicidal efficacy. So depending on what the chemical is used for, the concept of efficacy will change. Because 3D is largely on drugs, we are talking about therapeutic efficacy. Now, how can therapeutic efficacy be defined? Therapeutic efficacy, if you see the language of 3D, they talk about enhanced therapeutic efficacy, which means we expect therapeutic efficacy to be there in all drugs. The new version of the drug, if it has enhanced therapeutic efficacy, then we'll grant you a patent. Otherwise, we won't grant you. We'll treat it as the same substance. This is the sum and substance of 3D. Now, enhanced therapeutic efficacy can be understood in many ways. One, I need to have 1,000 grams of a medicine. That's the older version. Now I'm just having 500 grams, and it does the job of the 1,000 grams. That's one way to look at enhanced therapeutic efficacy. That's an easier way to look at it, because the more purer the form is, the more bioavailable the form is, you will have enhanced efficacy. So, but that's not the main argument. And the courts have rejected that to some extent. The patent office has rejected that to some extent. The other way to look at therapeutic efficacy is if a drug treats me in 6 days, the new version of the drug cures me in 3 days. Now, that's therapeutic efficacy for you. That's enhanced therapeutic efficacy for you. So this is how you understand it. Efficacy is understood as the effect of a drug. The effect of the drug is to treat, or to have a therapeutic effect, or treat that disease or that ailment. And you see whether there is enhanced efficacy to see that whether the treatment is much more efficient, whether it's faster, whether it's quicker, whether it is complete. In some cancer drugs, whether it is complete. And this is how you understand it. Hope that answers your question. Yeah, welcome, Rajesh. Okay, so we are just heading to the end of our session. If there are any further questions, I would want you to please raise them in the forum. I could answer them. We could answer them on the forum, or I can just record my voice like this and post it there, so that, you know, I find the voice much better, because text has its limitations. The voice, you know, you can go on and people can engage with it as though they are listening to the person in real time. Yeah. So thank you so much again for joining us. And if you have any follow-up questions, please use the forum. We are there to address your issues. and all the very best for your exam. That is this exam, patent law for engineers and scientists. And for those who are taking this in May, if you are taking the patent agent exam, all the very best for you as well. And I can tell you that you are in really good company. There are quite a lot of people who have taken this course, professors who didn't even intend to practice in the patent office, who have cleared this exam in flying colors. So you're in good company. Yeah, thank you so much, and do stay in touch with us. And if you have anything, please use the forum. Thank you.
Thank you, everyone. Thank you, sir.
Thank you. Bye-bye.
Bye-bye.